4. Matters relating to charters are dealt with at this stage. 5. It is a valuable document in the hands of the parties. The vendor can tender it as evidence of expectation of money, while the purchaser can mortgage his equitable interest. 6. It prevents gazumping, selling the property at a higher price after the contract of sale, and gazundry, refusal to buy the property because of an offer to buy at a lesser price. 7. Both parties can procure collateral advantages, e.g. the purchaser can take possession before the completion of the sale. 8. It is easier to enforce the terms of the contract because they are already clearly stated. Pre-contract enquiries. The law does not place any obligation on the vendor to disclose any defect on his title to the property to the purchaser, especially where such defects can be discovered by mere inspection of the property. To this effect, the purchaser is advised to carry out an inspection of the property. Once the contract has been exchanged, the purchaser is bound by these facts, for which the law places a duty on him to inquire, i.e. caveat emptor, buyer beware. However, it has been declared that the doctrine of caveat emptor only applies to patent defects and not to latent defects. Latent defects are defects which cannot be discovered by mere inspection of the property at that particular time. Very important, where inquiries have been made and there is a misrepresentation on the part of the vendor, such a misrepresentation is actionable. Exchange of contracts. This is a procedure by which the parties become bound by the contract. While a deed takes effect upon delivery, a contract takes effect when it is exchanged. Awujugbabe Light Industries and Chinukwe, 1995, LPELR 650SC. In and ISOs 1980 CH 548, exchange of contract was stated thus. Exchange of contract for sale is effected so soon as each part of the contract signed by the vendor or the purchaser is in the actual or constructive possession of the other party or his solicitor. There are two possible situations: 1. Where the parties act by separate solicitors. 2. Where the parties act by the same solicitor. Where parties are represented by several solicitors, the solicitor to the vendor prepares the draft and sends him to the purchaser solicitor for possible amendments where they exist. It is important for the purchaser solicitor to peruse carefully. If the purchaser agrees, he returns the draft to the vendor solicitor, who prepares copies and sends to the purchaser solicitor, who signs. Thereafter, the parties will sign the copies and exchange physically. All parties use the same solicitor. Where parties retain the service of the same solicitor, there will be no exchange of contracts. This is advisable only: 1. Where the terms of the agreement have been so clearly agreed upon and parties have agreed to use the same solicitor. 2. Where the transaction is of little legal consequence. 3. Where the title to the property is certain and there is no conflict of interest. 4. Where the parties are established associated companies. Status of the parties after the exchange of the contract. 1. After the exchange of the contract, the vendor becomes a qualified trustee. 2. Is the owner of the balance of the purchase price. 3. Owes the property interest for the purchaser. 4. He has a lien on the property to the extent of the unpaid balance. 5. The vendor is entitled to rent and profit on the land, although he must account to the purchaser. 6. The purchaser at this point becomes the equitable owner of the land, which may assign mortgage or lease. And 7. He can obtain an injunction to protect his interest by restraining the vendor from transferring the property or committing voluntary waste on the property. Effects of death of the parties. Where either party dies, the personal representative can complete the transaction. For an insane person who did not enter the contract during his lucid moments, the contract will be said to be void and invalid. Sample draft.